So good morning, everybody, and welcome to today's webinar, where we're going to look at the conveyancer's overview of forfeiture of lease and rent charges indemnity insurance with CLS. My name is Faye Stenning and I'm a marketing manager here at InfoTrack, and I'm delighted to be joined by Steve Johnson, who's the Business Development Director at CLS, and he's going to be taking us through today's session. So before we begin the webinar, I'd just like to draw your attention, please, to the Q&A tab, which is located at the bottom of your screen. We will have a Q&A at the end of this webinar, so please do type in any questions that you might have for Steve, along with your name, into the Q&A box. We are going to do our very best to answer the questions that come through, but because this particular webinar is quite a niche area, we may need to take some of the questions offline and come back to you separately with answers. So please do use the Q&A box so that we can make sure we capture your data and then we can come back to you directly after the webinar. So without any further ado, I would like to hand you over to Steve so that he can take you through today's webinar. Thank you very much.
Wonderful. Thank you very much, Dee. Much appreciated, Faye, much appreciated as always. And yeah, as Faye introduced, we're looking at forfeiture of lease and rent charges, a guide for conveyancing. You have myself, Steve Johnson, CLS Property Insight Business Development Director, and Faye Stenning, InfoTrack Marketing Manager. And as you can see on screen, we're looking at about a 40-minute presentation with the learning objective to provide an overview, the forfeiture of lease and rent charge issues, and some of the insurance solutions that are available to you through CLS and InfoTrack. So our agenda for today, we're divided into three sections. Section 1, forfeiture of lease. What is forfeiture of lease? Section 146, forfeiture notices, breaches of covenant, and the Housing Act and Leasehold Reform Act. Then we're going to be part 2, freehold rent charges, background and definitions of, and then wrapping up with the insurance solutions for forfeiture of lease, Housing Act, freehold rent charges, and a brief summary and close. But starting with part 1, one of the remedies, of course, available to landlords if a tenant breaches the terms of a lease is the right of forfeiture. So what is forfeiture of lease? Well, forfeiture is a means for a landlord to terminate a lease in the event of some default by the tenant, i.e. a breach of the terms of the lease. Forfeiture is effectively a possession process and allows the landlord to take back possession of the property from the tenant via the courts. Now, in order for this right to be available to the landlord, the right must be conferred expressly within the lease, i.e. there must be a forfeiture clause within it. Now, some of the most common reasons for forfeiture of lease are bankruptcy or insolvency of the tenant, which is why most lawyers will not accept a lease that contains such a clause. Breach of covenant, as per the covenants set out in the lease, and why tenants should be carefully advised as to what those covenants are prior to the purchase of a leasehold property. And the issue of outstanding ground rent, which is likely to be a breach of covenant, but of course also result in a Section 8 possession proceedings, depending on the amount of ground rent in the lease. Now, our main focus for today is looking at the risk of a landlord forfeiting the lease or exercising a legal right of re-entry to the property under Section 8, Ground 8 of the Housing Act 1988 as a result of outstanding ground rent due from the borrower under the long lease of the property. But it's also important we consider an overview of the law in this area and other possible scenarios to get a better understanding of this particular risk. So, how does forfeiture of lease come about? Well, depending on the reason for forfeiture, termination of a lease can take place with immediate effect or following a period of notice. There are two ways for a landlord to forfeit a lease. One, by physically taking back possession of the premises, often described as peaceable re-entry, or by issuing and serving proceedings. In order to be able to forfeit a lease, a landlord must establish the basis of their right to do so as per the terms of the lease. The most common way is via a clause in the lease which grants the landlord the right to forfeit in certain circumstances. For forfeiture to take place, the landlord has to issue a Section 146 notice in order to conform with the requirements of the Law of Property Act 1925. The landlord cannot just take back possession because the lease has been breached. They must follow the required procedure. This is because Section 2 of the Protection from Eviction Act of 1977 states that it is not lawful to forfeit a lease without going through the courts. What then is a Section 146 forfeiture notice? The Section 146 procedure applies to both commercial leases and residential long leases, i.e. a flat or a house with a lease longer than 21 years, usually being one where a large premium was paid originally to buy the long lease for typically 125 years, where rent is not paid annually, a small amount of ground rent is paid annually, possibly a service charge too. So a Section 146 notice is a notice served under Section 146 of the Law of Property Act 1925 by a landlord to their tenant to terminate a lease early due to a breach by the tenant of the terms of the lease. It is only possible to issue such a notice if there is a right to forfeit the lease, right to re-entry, written into the lease. The notice confirms that forfeiture proceedings will be brought because a covenant in the lease has been breached. The notice must contain certain prescribed information. It must include details of what the breach is. If the breach can be fixed, a request to fix the breach in order to avoid the proceedings, and details of the monetary compensation required if that's applicable. The landlord must give the tenant reasonable time to fix the breach. This will be what is reasonable in the circumstances, depending on what the breach is. Most breaches will be capable of being remedied. However, some breaches, such as a breach through assigning the lease, will not. If the breach is capable of remedy and the landlord does not give the tenant a reasonable opportunity to fix the breach, then the notice will be void in accordance with Section 146 1B of the Law of Property Act. Under the Law of Property Act, the landlord is entitled to monetary compensation for the breach. The monetary compensation required must also be reasonable and could include, for example, surveyor's fees. If the breach is capable of being remedied, then the landlord has to give the tenant the option, or that option, and provided the tenant makes good the breach, then the landlord cannot take possession of the property. If the tenant does not fix the breach within a reasonable time, then the landlord can commence proceedings in the county court for forfeiture. It is also worth noting that for residential long leases, the landlord does not need to follow the Section 146 process in order to forfeit the lease if there has been a failure to pay the ground rent. In such case, the Section 146 notice is not needed, and the landlord can move directly to issue proceedings in the county court to repossess the property. However, usually the landlord cannot serve the notice if the lease has been breached for non-payment of the rent, service charges, or administration charges, unless the amount owed is either over £350 or includes part that has been unpaid for 3 years, subject to the provisions in the Housing Act, which we'll be discussing shortly later on in this webinar. So what then are the most common types of breaches of common breaches of covenant? The types of covenant that are commonly breached include the following: failure to pay service charges or ground rent, just as discussed, failure to maintain and repair the property, unauthorized alterations, nuisance behavior, breach of covenant not to keep pets at the property, or subletting the property, of course, without the landlord's permission. Now, with regard to escalating ground rent, a major reason for forfeiture of lease is non-payment of ground rent. I'm sure you're already aware of that. Ground rents are an annual payment to the landlord in return for the grant of a long lease, with the landlord ultimately having the property back at the expiry of the term. Ground rents on leasehold properties have caused many problems over the years, with some doubling to create unmanageable financial situations for many occupiers. To add to the problems, many mortgage lenders will not lend on properties where ground rent exceeds a certain value. This has meant property owners could find themselves in a situation whereby they are unable to sell their property as no potential buyer can raise the finances to purchase it. If a purchaser is buying a leasehold property where the lease contains provision for escalating ground rent, they should consider the legal and financial ramifications. By the time the ground rent clause is in the lease is discovered by the conveyancer, the buyer is already committed emotionally and financially to their purchase, having spent money on survey and searches and some such. Now, historically, ground rents were low fixed rents with no review or reviews at infrequent periods during the term. However, sadly, times have changed and landlords now frequently include rent reviews within their leases. There are broadly 4 types of ground rent beyond the historic type, which typically feature review periods of 10, 25 or 50 years. A, increasing the rent by a fixed amount each rent review period. B, doubling the rent each rent review period. C, rebasing against the retail prices index at the end of each period. And D, rebasing the rent against a percentage of the capital value of the property at the end of each period. There's been a lot of press coverage about ground rent escalation clauses in residential leases, and in particular, new build properties and the adverse impact they can have on resale value if the escalation is too quick. Some owners have found their leasehold property has a hidden issue in a ground rent clause, which doubles the rent after a specific period or at set periods throughout the term of the lease. For example, a ground rent of £250 per annum, which doubles every 10 years, would be £64,000 per annum after 80 years. This is a rate increase over the first 30 years of 800%, which would clearly far outstrip any inflationary increase, we hope, which these types of clauses purport to cover. Rent review clauses are not uncommon or necessarily unreasonable. Rent increases should be checked carefully in case the increases are unfair or unreasonable. So, what is lease forfeiture under the Housing Act 1998? Well, that said, if the ground rent in a lease is more than £250 per annum outside of London, or £1,000 per annum within London, in properties being occupied by a tenant as their only or principal home, current legislation means that any leases with a ground rent above these limits could result in them being classed as an assured tenancy under the Housing Act 1988. This issue has arisen in leases that have started to contain unfair ground rent escalation provisions, such as doubling every 10 or 15 years over a term of 999 years. This results in extremely high ground rent, which could affect the value and future marketability of the property. Now, the Housing Act of 1988 affects all homeowners and buyers who own or are buying a leasehold property that is subject to a ground rent if the ground rent is £250 a year or 1,000 or more in London. 1,000 a year or more in London, sorry. Under the Act, a freeholder can serve notice to forfeit the lease for non-payment of ground rent, and the leaseholder and their lender have no right to seek relief from forfeiture of the lease. Ground 8 of the Housing Act of 1988 allows a landlord to apply to the court for an order to take repossession of a property where the ground rent is 3 months in arrears. And as this is a mandatory ground for possession, the court cannot refuse such an order. If the ground rent is very high, there was more chance of a tenant falling into arrears, allowing the landlord to take possession. In normal leases, there is no requirement for the landlord in this situation to notify the mortgage lender that they are looking to take possession. And as this is a mandatory ground and the court cannot refuse to grant an order for possession, a lender could end up losing their security without even knowing it, by which point it would be too late for them to pay the arrears. Ground 8 is particularly relevant as it covers mandatory grounds for possession for an assured tenancy and concern arrears of rent. The mandatory nature of ground 8 means the judge cannot refuse to make the order. So effectively, if any tenant were more than 3 months behind in their rent, a landlord could apply to the court for a possession order to evict the tenant, and this would automatically be granted. Ground 8 and the implications that it can cause on lenders' security is the reason that most lenders now have guidance on the levels and future increases of ground rent that they will be able to accept. As property solicitors, it's felt broadly that there is a duty of care, of course, to purchaser and to lender. Forfeiture of Lease Housing Act legal indemnity insurance could provide an acceptable risk management solution for lenders to enable informed purchasers to proceed with their leasehold house purchases. We'll touch on that as a potential solution a little bit later on. So what then happens if notice to forfeit is served? Well, if lease forfeiture is granted by the court, this means that the lease of a property is brought to an end and the property is handed back to the landlord, i.e. the freeholder. The property owner then loses their leasehold title, and the mortgage lender loses their security for the loan. Now, to avoid this, some lenders have paid the borrower's ground rent arrears to avoid lease forfeiture and then added the sums to the borrower's mortgage account. However, this is not usually available if possession is being sought under Section 8, as discussed on the previous slide, because the lender is unlikely to be aware of the proceedings. A lot of lenders have now adapted the following. The maximum ground rent at the start of the lease term must not exceed £1,000 a year. The ground rent must not be capable of being increased during the first 21 years of the lease, and not more frequently than every 21 years during the rest of the lease term. Where the ground rent is reviewed, any increase must not exceed the higher of 100% of the ground rent payable immediately before the date of the rent review. With a number of lenders specifically also saying they will not accept ground rent provisions that contain unreasonable multipliers, i.e. doubling every 5, 10 or 15 years. With escalating ground rent provisions in many leases, potential exposure to forfeiture is not an acceptable risk to many lenders, unless there is protection through some form of Forfeiture of Lease Housing Act legal indemnity insurance. Now, on February 8th February 2022, the new Leasehold Reform (ground rent) bill received royal assent, officially making it an Act of Parliament. The Act will be brought into force within 6 months of this date, possibly sooner. An aim of the Act is to address the problem of escalating ground rent by reducing ground rent to what is known as peppercorn rent, effectively making the ground rent payment nothing, with freeholders who do not adhere to the new rules getting their leases amended and also facing large fines. The new law means that ground rents on new non-retirement leasehold properties will have to be effectively zero. The Act puts an end to ground rents for new qualifying long residential leasehold properties in England and Wales. And this is part of the most significant changes to property law in a generation. It's hoped the Act's provision will lead to fairer, more transparent home ownership for thousands of future leaseholders. While the Act focuses specifically on ground rent clauses within future long residential leases, further leasehold reform is expected to follow later by Parliament. Once it commences, this Act means that if any ground rent is demanded as part of a new residential long lease, it cannot be for more than one peppercorn per year, meaning that future leaseholders will not be faced with financial demands for ground rent. The Act also bans freeholders from charging administration fees for collecting peppercorn rent. Parliament are also enforcing the charging of a prohibited ground rent by way of a civil penalty regime, including fines of up to £30,000 for freeholders that charge ground rent in contravention of the Act. Unfortunately, however, for existing leasehold property owners, the Act is not retrospective, meaning that whatever terms are already in your lease applying to ground rent, they will remain in force. For those currently buying, most developers are already making ground rent a peppercorn rent in anticipation of the forthcoming law coming into effect. However, currently, new leases to summer 22 can still currently contain clauses that charge the leaseholder and still be subject to doubling or other some such troublesome issues. no doubt lawyers will be looking to negotiate leases now based on this incoming piece of legislation. Now, ground hold rent should not be confused with freehold. And at this point, we move into section 2 of our presentation, freehold rent charges. So what then is a freehold rent charge? Well, this is an annual sum paid by a freehold homeowner to a third party who normally has no other interest in the property. Most rent charges are part of a historic system whereby landowners who released part of their land for development could then charge regular payment from the people living on it. Once imposed, the rent charge continues to bind all land, even in the scenario the land is later divided or sold off in plots. So, for example, one homeowner can be made responsible for paying a whole rent. That individual is then left to collect the appropriate portion from the other householders whose land is subject to the rent charge. Now, I'll give some of the commonly used definitions here for a bit of further information and context. A rent owner is a person who receives a rent charge payment and then has no other legal interest in the property they collect from, as such mentioned in the previous slide. A freeholder or homeowner, a person who owns their property and is responsible for paying the ground rent. Excuse me. And then ground rent is a similar concept, but is only applicable to lease properties and cannot be redeemed. Oh, we're coming in now to section 3 of the presentation, and here we'll touch on some of the insurance solutions we may have already referred to. Some of you may already be customers of CLS insurance through the InfoTrack platform, and my thanks to you, for those of you that are. For anyone who isn't, you may not be aware that the CLS full indemnity suite is available through the InfoTrack platform as part of the overall InfoTrack environment that they operate. If anyone wishes to get any demonstration of that aspect of the platform, please do get in touch with Faye or myself, or if you're an InfoTrack client, with your account manager at all. They'd be very happy to show a demonstration, and if necessary, sort of focus in on one or two of the policy aspects we're just going to touch on over these few remaining slides. So on the right of the screen, you can see a sample of the CLS Forfeiture of Lease policy. We will be sending out a sample of this policy with the documents that accompany the end of this webinar as well, so you'll have that to refer to should you need it. This policy, of course, protects the lender if the landlord forfeits or attempts to forfeit the long lease. You note, of course, that the limit of indemnity is typically the outstanding mortgage amount granted to the borrower, and the period of insurance is from the inception date, continuing for a period coextensive with the term of the mortgage. And premiums for this policy start from £22 or so. Now, I won't go through all of the statements of fact here, but it just did want to say that one of the functions that InfoTrack have adopted and broadcast out to the clients that relate to the CLS policies is something we call variable statement of fact. What it means is that as you travel through the CLS insurance ordering process on the InfoTrack platform, if one of the statements of fact that you see, an example here on screen, doesn't coincide or match with the nature of your client's transaction, what you're able to do is select from a pick list of other statements of fact. And the hope is, of course, that in all but the most exceptional of cases, that means you're able to then create a policy that matches specifically your client's requirements. Of course, that echoes the requirements that are set out in conduct of business rules that come from the Insurance Distribution Directive of October 2018. And from a practical point of view, it means you're able to complete that policy online, even if the base statements of fact, the first ones you saw, didn't quite fit your client's transaction. As I say, those drop-down menus enable you to pick a statement of fact that best reflects your client, the nature of your client's transaction. You would then see that amendment reflected in the online policy when necessary in the pricing of the policy as well. But the key thing here is first of all, you have a policy that mirrors exactly your client's requirements. And secondly, you have a policy that you can create as a draft and subsequently order online rather than having to drop off and have a potential delay, however well-intentioned, caused by having to refer across to an underwriter for a manual review. But in relation to the forfeiture of lease policy, as I say, we have the statements of fact up there on screen. You'll get a copy of them, as I mentioned, so I won't read them all out, but A and B are the standard terms you'd expect to clarify in relation to the property. And in addition, there are statements within there that ensure the solvency and affordability checks have been carried out on the borrower, and also that check that there are no outstanding payments on the lease or issues that could give rise to a claim at the point when the policy is being incepted. Once again, we can see just a sample of the freehold rent charge insurance policy. And again, we'll send out via InfoTrack a sample of this policy with the notes and slides from this presentation. The insured risk is, of course, that the property is where the property is subject to a rent charge referred to in the Land Registry Title Register at the inception date, and it protects the insured party as a result of the property being burdened by a rent charge payment and their inability to locate the rent charge owner. Once again, the limit of indemnity is the amount stated increasing to match actual increases in the value of the property, up to a maximum of 200% of the sum stated over the lifetime of the policy. And once again, there you can see the statements of fact applicable to the to that policy, to the freehold rent charge policy. But once again, you'll experience sort of within the InfoTrack platform those variable statements of fact, meaning you increase the likelihood, no matter how varied your transaction might be, of being able to obtain a policy online, and obviously from there crack on with the remaining parts of the conveyancing process that take your clients through. So my thanks to all of you for joining, and my thanks to Faye for setting up and hosting the webinar. To summarise and close, really, obviously in the current climate, some tenants may struggle to meet their rental payments, both residential and potentially commercial property as well. Forfeiture of lease can come about from a breach of various covenants, the most common being non-payment of ground rent. Freehold rent charges are not to be confused with ground rent. Rent charges are a sum of money paid by a freehold owner to a third party. And of course, legal indemnity insurance provides an acceptable risk management solution that enables purchasers and lenders to proceed with their housing transactions in a timely fashion. And you can, of course, contact your InfoTrack account manager or come to me for reference across to InfoTrack for access to the CLS indemnities within their platform, where you can see sort of the ease with which quotes and policies can be produced. And as we sort of mentioned throughout, there will be policies and a copy of the slides, and I believe, Faye, there's going to be a recording sent out post-session as well. So I hope this has been very useful. My thanks for watching. And Faye, if you're happy to come back in now.
Absolutely. Thank you very much indeed, Steve. That was very informative. We have had some questions come through, and as I mentioned at the beginning, this is quite a complex area, so we'll do our best to answer them, but some of them we may need to take offline. But any that we do take offline, we'll share the answers with everybody on this webinar when we share the recording and the slides and the draft policies. So the first question then, Steve, is there a policy which will cover both a purchaser and a mortgagee?
Not as standard, but that would be a bespoke policy. So if that's something that, if you have that question, very happy to put you in touch with our underwriters, and then we can explore the sort of the specifics of your transaction. I won't mention your name in this forum, but we can see obviously who's posted the question. So my thanks on that. For those of you that use the InfoTrack platform, there is a mechanism by which, if a policy can't be fulfilled online, even with those variable statement of fact functions, there's a function by which you are automatically referred across to the CLS underwriters, who will then proactively reach out to you. You don't have to make contact with them. They will reach out to you, then sort of explore the nature of what you need. So I will take your name as posting that question and put you in touch with one of our underwriters.
Okay, that's lovely. Thank you. The next question is, Do your forfeiture indemnity policies cover the situation where the client is a non-private individual? So, for example, a company or a trust, etc.
Yeah, I'm going to, thanks again for that. Again, we've got your name on screen. I'm going to refer that across to our underwriters, please. Okay,
lovely. Next question is, are you able to share anything about estate rent charges, including indemnity? Sorry, this person's apologised if we've already covered this because they joined a little bit later.
Yeah, I think I'll come back to you on that one if that's okay.
No problem at all. Okay. Okay, next question is, can you apply for a possession order if a person is subject to a bankruptcy or an IVA?
I think the nature of that question, obviously we're an insurance business, so I think we produce these courses in conjunction with legal experts. So I'll take that away if that's okay, Faye.
Okay, no problem. The next person has said they just wondered if you've ever had a policy like this with a claim, and if so, can you give us an example of how you dealt with the claim and what the outcome was for the client or the lender?
Yeah, I'll put a claims case study into the document which follows up. So the majority of our policies do have claims against them, despite I know there's sometimes a school of thought that these things never get claimed against, but yes, they do have claims against them. One of the things that we'll put into the typical sort of claims case study is not just where the nature of the financial settlement was ultimately reached, but also the nature of the professional expertise that was accessed through the claims process, whether that's relating to surveyors, whether it's legal expertise or some such. And quite often you find that the overall value, financial value of access to expertise sometimes is significantly higher than where there's a financial payout at the end of the claims process. So one always tries to think about the sort of the claims case studies that we have in those two terms: access to expertise and the financial value where you'd otherwise have had to pay for that, and of course what the ultimate financial settlement looked like.
Okay, perfect. Have there been any cases of a long lease being forfeited under the Housing Act for non-payment of ground rent over £250 or £1,000 if in London, or is this still a theoretical risk?
I don't know, but I will find out for you.
Fantastic, thank you. I think this one is probably one that you probably want to take offline as well, but Barclays don't seem to accept insurance and require a mortgagee protection clause in the lease or an undertaking from the landlord to serve notice to the lender. I don't think that's really a question, more of a statement. So I'll move on to the next one. Under ground 8, does the ground rent have to be 2 months in arrears, both at the date of the service of Section 8 notice and the date of the court hearing, for the court to have no discretion on awarding possession? Yeah,
I think, Faye, if this is okay, I can see that question that's come through, and actually some of the later questions here. Would it be okay if I take those away? What I'd like to do obviously for the people that have asked them, and also for the other for the remainder of the audience as well, is get these into a sort of a fully documented Q&A document, which we can share sort of reasonably soon after. Okay, I think the nature of these questions, they're entirely valid, and I'd like to be able to make sure we get sort of expert review of them and able to provide a documented answer, which you can then refer to back and sort of have to hold locally. And I say that would go out to all of the attendees, not just those who asked the specific question.
Okay, yeah, that's no problem at all. We'll get all of the questions shared with you, and then your underwriters can go through and review them, provide the answers, and then we'll share the Q&A with everybody that's joined this webinar so that they'll have everything to go through to hand.
Yeah, thank you. But my thanks to everyone who has asked questions. They're extremely topical. So yes, my thanks to those, and we will get good answers out to you.
Okay, that's perfect. In that case, then, I would like to say a very big thank you to you, Steve, for your time today. And I hope everybody's session informative. Certainly, we've had lots of comments to say thank you. So it seems to have been very informative and well received. So thank you very much. And also thank you everybody else for attending and joining us this morning. Thank you for your time. And as I said, I hope you found it useful and enjoyable. And so we'll bring this to a close, but we will be sharing the recording and all of the other bits of information that we've mentioned with you, either later today or tomorrow, or as soon as we've got the Q&A. That might take a little bit longer, but the recording we can share sooner. So I'd like to thank everybody for joining us. If you need to contact us, please do so using the details on your screen or reach out to your account manager if you've any other questions. And all that remains to be said is to enjoy the rest of your day. Thank you very much indeed for attending. Take care. Bye-bye.